Good afternoon, everyone, and thank you for joining us today for our presentation of the estate plan of the month here for April 2025. Despite what my name says there, I'm Christy Nicolo, not Alan Gassman. Sorry to disappoint some of you who may have been expecting Alan, but I hope that maybe I can give you some helpful pointers and tips on how we do things with respect to a certain estate plan that you will take away and be able to use in your practice. And I hope I will be a tenth as entertaining as Alan is relative to jokes and otherwise. So first, I really want to just mention from a 30,000-foot view, the idea behind this presentation is not to get into every little nuance and detail over an estate plan that we've used. I do not have language to review today. We're not going to go over trust provisions. What I intend to do is review a chart that you are hopefully seeing in the window here to show you how we've implemented certain tax planning and other techniques and mechanisms for a family to help reduce an estate tax situation down to zero in this case. Now, admittedly, this estate plan is not exactly something we've done for a particular family. This is kind of a hodgepodge of what we've done for several families in a manner where we can show some of these concepts and how they may be applicable. That I think is a better way to do it as opposed to going over the detail and specific circumstances that applied to the family in question. But here you'll be able to see a variety of techniques and how we've implemented them over the course of their planning. So without further ado, I'll jump onto this Microsoft Excel worksheet here that hopefully you have and hopefully you can see for Mr. and Mrs. Smith. And the names have been changed, of course, to protect the innocent. Mr. and Mrs. Smith are clients of ours and have been for decades. They have a long-standing, healthy marriage and have two children, kind of a blended family, but not really. One child is the common child between them, and the other child is a non-common child, but is the child of one spouse, but for all intents and purposes is considered to be a child of both spouses. And that is important here because we treat the children fairly based upon how this structure was implemented. In some situations, for a lot of clients, we are treating one child differently from the rest or vice versa because of certain circumstances relative to the child's ability to handle money or reasons why the child should get more or less or have more or less restrictive provisions that apply for their benefit. I also wanted to mention that in this particular situation that we're going to review today, there are a variety of unique circumstances as it pertains to asset class. In the client whose situation formed the majority of the basis for what we're going to discuss, there is a concentrated position, there was at least a concentrated position in a private company that appreciated significantly, which with early estate tax planning allowed us to push significant wealth out of the client's estates and out of the estate tax system based upon current law. Not every client has that situation, but some do. And that situation does not necessarily preclude us from using the techniques that we've shown here. So without further ado, jumping onto the chart, many of you have seen this type of chart that we run for clients. We like to map out everything in this manner. That way, it's easy to understand. It's easy to review quickly, particularly if the clients reach out in 5, 6, 7, 8 years and want to talk about something specific. We can revert to the chart, go back and take a look as opposed to digging through documents and trying to reconstruct what happened. So in this client, we have John Smith, Mary Smith, right? Our married couple. Here in Florida, they have the benefit of tenants by the entireties, which in Florida is a very unique creditor protection tool that can be used for married couples. Quite simply, what it says is that a husband and a wife can own assets jointly as tenants by the entireties. If one spouse were to get sued for a creditor situation that has nothing to do with the other spouse, not a joint debt, just a singular debt against one spouse, then any suits against that one spouse, the creditors cannot attack tenants by the entirety's assets. That is beneficial, that is helpful, because it allows for those assets to be protected from creditors. And for that reason, Mr. and Mrs. Smith have held their assets jointly as tenants by the entireties, to some extent at least, right? So this involves their bank accounts. They have their homestead property owned in this manner. I think in the actual client situation, there may have been some personal property that was valuable that was owned in this manner. But tenants by the entireties is not a panacea. If one spouse dies, as is the case here, where I don't have the date of death on here, but let's just say Mr. Smith died on March 1, 2025, right? On his death, the tenants by the entirety's assets would have passed 100% to Mrs. Smith, outright and free of trust, which may effectuate a lot of what clients want to occur, but the assets that pass to Mrs. Smith after the first death do not take into account any kind of creditor protection. So Mrs. Smith, she has a creditor situation after Mr. Smith's death, then you don't have creditor protection. Whereas if assets are owned jointly under a trust or under a separate revocable trust for Mr. Smith, those assets can be held in a creditor protected manner outside of the estate tax system to the maximum extent possible, and that might be more beneficial for the clients. So in this case, what we've done for Mr. and Mrs. Smith, we have implemented a joint trust. This joint trust is a JEST type trust, a joint exempt step-up trust. And I can spend 2 hours talking about the JEST trust by itself. I'm just going to mention this. It is a type of joint trust that our law firm has developed, and it allows the assets held under the trust to be eligible for a step-up in income tax basis. All assets under the trust that otherwise would be eligible for a step-up in basis, to get a step-up in basis on the first death in the event of the first dying spouse's death. After the first death, the assets in the trust are going to be divided into separate trusts depending on the value of the assets. And we accomplish this by saying the first dying spouse is going to have a general power of appointment, or the power to appoint the assets in the trust to his or her creditors, in this case, Mr. Smith's creditors, so that under the JEST trust, we have a share that Mr. Smith created, we have a share that Mrs. Smith created by her share of assets under the trust. On Mr. Smith's death, Mrs. Smith's share of the assets are subject to Mr. Smith's general power of appointment, and those assets are included in his estate and pass into one or more trusts. These trusts are the Family Trust A and Family Trust B. Family Trust A is funded with Mr. Smith's share of the assets, so 1/2 of whatever the couple put into the trust. And Mrs. Smith's trust, Mrs. Smith's share funds Family Trust B. And they are virtually identical in that they are irrevocable trusts where Family Trust A is held for the benefit of surviving spouse and descendants. The Family Trust B, however, is not held for Mrs. Smith, because we do not want Mrs. Smith to be a beneficiary in order to increase our argument that we get a full step up in basis on all assets under the trust on death. Trust protectors, an independent committee of trust protectors, could appoint Mrs. Smith as a beneficiary, but my advice on that would be not to do so unless or until all other assets available for Mrs. Smith are exhausted. Now, in this instance, we had a situation where the assets in the joint living trust were structured so that Mr. Smith's share was worth less than Mrs. Smith's share. His share was worth somewhere in the neighborhood of around $2 million. Her share was worth somewhere in the neighborhood of around $13 million or so. So there was an excess of what Mr. Smith could use by his general power of appointment to shield assets from estate tax on the first death. So anything in Mrs. Smith's share that exceeded what remained of Mr. Smith's estate tax exclusion went to a separate Mary Smith family trust, which functions like a revocable trust for her. She has carte blanche authority for the trust. It's not creditor protected, but in this case, the assets allocated to the Mary Smith Family Trust were not significant. So that is a kind of a high-level view of how the jest works, and it worked out very well for this family. Now, this family also had the benefit of implementing early on irrevocable trusts and estate tax planning techniques that were able to push out a lot of wealth for the clients, so that we wouldn't have an estate tax on certain assets or on the appreciation of certain assets. One of those assets is this Smith Holdings LLC, which was an LLC funded with investment assets. John Smith was the manager when he was alive. The 99% non-voting interest was owned by the Smiths jointly. It was then transferred to Mrs. Smith, right, years ago. She held it for a couple of years, and then she sold that 99% interest in Smith Holdings to the Smith Descendants Trust in exchange for a promissory note. This is the installment sale to a grantor trust technique that many of you have heard before, and it really involves having a grantor of a trust sell to an irrevocable grantor trust a non-voting or ownership in an LLC or some type of other asset to the trust in exchange for a promissory note to freeze the value of the asset, so that any appreciation in the asset above the interest rate that applies on the note would be outside of the estate tax system. In this situation, the Smith Descendants Trust is an irrevocable trust that benefits their descendants, their two sons, Mark and Paul Smith. The trust was initially structured as a Nevada trust, so Mrs. Smith could be added as a beneficiary if she were having a net worth below a certain threshold. That never came to fruition. In fact, the trust after Mr. Smith's death was moved back to Florida, but this is what we did as part of the arrangement. And on the sale by Mrs. Smith to this trust, there was no income tax because the trust is considered to be a grantor trust for federal income tax purposes. So now we have this promissory note that was payable to the Smith Joint Living Trust. It was payable to Mrs. Smith. She assigned it to the Joint Living Trust. It ended up in her share, which in turn was allocated to Family Trust B or the Mary Smith Family Trust based upon what I discussed earlier. The interest rate under the promissory note was very low. I think it was like 1.26% due to it occurring in December of 2021. Back then, it seems like a long time ago, interest rates were a lot lower than they are now. And as a result, the assets under the Smith Descendants Trust, for example, this ownership interest in Smith Holdings LLC, appreciated significantly. In fact, these assets grew from about, it says 12 million here, they grew from about 12 million up to around 17 million, and then some of the assets were used to pay down some of the note. That's not shown here, but that's kind of how this mechanism works, is that a distribution would occur from Smith Holdings LLC, pro rata to ownership. Smith Descendants Trust would then make a payment to the Smith Joint Living Trust. And what we've done by using this jest mechanism in conjunction with the installment sale, we were able to freeze the value of Smith Holdings and freeze the value of the note because Mr. Smith had a power to appoint assets to the creditors of his estate for the purpose of freezing the value and locking in his credit on death, and also getting a step up in basis in what would be a note previously from a grantor to a grantor trust, not a traditional promissory note, not income in respect of decedent, based upon writings by Jerry Hash and other luminaries in the area. So it's a way to freeze assets and get an income tax benefit. This is a common technique, the installment sale to a grantor trust. Using the jest with it is not as common, but it's something that we really enjoyed using because it achieved the family's objectives of locking up assets on the first death and trying to get that stuff up in basis while pushing assets out of the grantor's estate. I'm also going to shift over to the right side here and show you something that we did for this family more than a decade ago. So most of you on the call are familiar with a grantor retained annuity trust, or a GRAT. And the way a GRAT works is that assets go into a trust for the benefit of the client, effectively for the grantor, by virtue of the grantor receiving annuity payments back from the trust in a manner where there's a remainder at the end that would pass to irrevocable trusts for the descendants of the grantor. And a GRAT is a little different from an installment sale, although the spirit of both techniques are similar. With a GRAT, you have a certain dollar amount or percentage of the initial contribution that is payable back to the grantor every year, right? So that percentage is determined with reference to an IRS promulgated interest rate. Based on the interest rates in place in 2011 when we did this first one, and 2014 when we did the second one, the payments were determined to be around 22% per year for a 5-year GRAT, right? We structured it that at the end of the 5-year GRAT term, actuarially there would be no assets remaining in these trusts. And that's important because that means the grantor is not deemed to have made a gift of any assets after the first or after the creation of the GRAT. As it turned out, the concentrated stock that I referenced earlier was transferred to these trusts, and that concentrated stock grew at a rate much higher than the IRS interest rate. So it left significant investment assets to pass on the end of this annuity term to a separate irrevocable trust. And what we did was a separate trust for each particular GRAT, so that you have a remainder, for example, for the 2011 GRAT goes to the 2011 investment trust. This investment trust was considered to be a grantor trust as to Mr. Smith until his death, when it became a complex trust. It allowed him to pay the taxes on the trust during his lifetime to permit him to transfer additional assets out of his estate without making gifts. That is a very important and beneficial tool that's sometimes called the grantor trust burn, and it can be very beneficial in moving wealth out of a grantor's estate. We also did a 2014 GRAT with a similar structure, except it passed to a trust for the benefit of Mrs. Smith and their descendants, but held in a manner that would make it a complex trust for federal income tax purposes. That way, Mr. Smith did not have the obligation to pay the income taxes associated with this trust, which allowed some flexibility in planning, right? They can invest these assets differently depending on how they want the income to flow. So these trusts grew tremendously. I put 50 million here. I meant to put 5 million under this Smith Investment Trust. Further down, you'll see they have an investment assets of about 1 million that were used under this LLC. So after Mr. Smith died in 2025, we merged the two trusts so that the 2014 trust was merged into the 2011 trust, and the idea being that we now have two complex trusts for the same beneficiaries. We merge them together. That should not cause an income tax problem. It also should not cause any shifting of beneficial interests. We also use the assets of, in this example, the 2014 trust to purchase a home for a child of theirs who had a minor child himself. And under Florida law, if an individual has a minor child and they die survived by the minor child, they cannot transfer their homestead property on death in any manner other than to their spouse. And in this client situation, he wasn't married, but he has two children who are pretty young, and he has an ex-wife who he, quite frankly, doesn't really care much for. And he did not want his young children to inherit this valuable house in a manner that would allow his ex-wife access to the asset. So what we did here was have an LLC created under the irrevocable trust that benefits the child. We funded the trust or the LLC, pardon me, with cash to purchase the house here in Orlando, nearby in Orlando. And the client entered into a 99-year, excuse me, the child entered into a 99-year lease agreement with the company so that he could qualify for the federal property tax homestead exemption, different from the homestead protection for creditors. This allowed the client to get the benefit of the lower property taxes for homestead exemption, and also remove the house from being under his homestead estate, so to speak, until his children are 18 and there are no restrictions on devise. So really important to implement the little wrinkle there. And that's the kind of flexibility you can use when you draft these irrevocable trusts with trust protectors, as you'll see here, where Alan Gassman, who you all well know, and the CPA for the family, arbitrarily named Ray Brown, were the trust protectors. And then the trustees of the trust were Alan and the two children. So the trust protectors could take advantage of establishing this type of LLC for planning purposes. The fact that we have a trusteeship, a co-trusteeship, was what the client wanted to protect against possible untoward behavior or possible misuse of assets. That is also very beneficial. I do want to mention that Mrs. Smith also is a beneficiary of both of these trusts, right? And that takes us back to, well, she's not a beneficiary of Smith Family Trust B, but we have millions of dollars available for Mrs. Smith. She's never going to run out of money available to her. And the fact that she's a beneficiary is very helpful here as part of this. And these trusts really, for lack of a better word, are SLATs, or spousal lifetime access trusts, in that they're irrevocable trusts created for the benefit of a spouse by another spouse. And it allows the first spouse, in this case, Mr. Smith, when he did his grats, to utilize the estate tax wealth transfer system to benefit the surviving spouse. That is very important to make sure that Mrs. Smith does not run out of money. Here on the far right, I'm just going to pay a little lip service to this ILIT, or Irrevocable Life Insurance Trust, that Mr. and Mrs. Smith funded back in the 1990s with a life insurance policy that matures on the death of the survivor. So now on Mrs. Smith's death down the road, the assets under this trust will mature, and the assets will be outside of her estate for federal estate tax purposes. I also want to add the assets in each of the 2011 and 2014 investment trusts will be outside of Mrs. Smith's estate for federal estate tax purposes. That was the benefit to using this type of structure when we implemented this. So Mrs. Smith has these monies available to her here, but on her death, we're not going to have any inclusion in her estate from an estate tax standpoint. So very beneficial as well. I did want to mention here, before I get into one final wealth transfer technique, we have the IRA for Mr. Smith. In this case, we had it rolled over for Mrs. Smith. And you'll see while he was alive, we did our chart showing what the required minimum distributions would have been based upon his age at death, based upon what the percentages were, and how the RMDs were structured. That, of course, has been rolled over into Mrs. Smith's estate. She is taking RMDs on that, and she is spending down those monies as required as they come out each year, right? That said, we're trying to stretch out as long as possible to the extent we can, because every distribution that comes out of an IRA is going to be considered as carrying with it ordinary income tax. So very important to consider as well. Also want to mention this little box here. On our charts, we often put how much lifetime gifting exclusion the clients have used. It's important to do so because we can revert back to this in years future and see what is remaining. Before we did this talk, I updated the 2025 for both her and him. If she wants to make a gift before the end of the year, we have this number available. If she doesn't make a gift, the exemption goes down next year as expected. Then we can come back to this in a few years and readjust and see what she has remaining. It really underscores the importance of good record keeping when we do estate planning, and this chart is really an integral part of it. All right, so the last piece of this puzzle is something that we used back in, I think it was 2020 or maybe even earlier, 2018. It was the SCRAT technique, right? The skin/GRAT technique. And here's how it worked. Mr. Smith individually owned a large position of concentrated stock in this private company that I mentioned earlier. He transferred it to an LLC that was called Smith Dynasty LLC, and he got back all ownership from the LLC plus a promissory note known as a self-canceling installment note from the LLC. And this self-canceling installment note worked just like the installment note that we mentioned earlier, except the installment note paid interest with a risk premium, because if he died prior to maturity on August 1, 2029, then the outstanding principal balance under the note would go away, right? It would be eliminated from his estate. The note would no longer be owing. And to be able to have that self-canceling feature, you must charge an interest rate that exceeded the then IRS promulgated rate. Back when we did this in 2018, the rates were, I think, 4 or 5% with the risk premium that we ran based upon actuarial tables and commercially available software systems. We had a 9% rate that was available, right? So the promissory note initially was 10 million. The payments were 900,000 based upon 9% interest, and each, he made there was a principal prepayment made, but each year interest payments were paid back to him from this LLC because there were investment assets that were held underneath this Dynasty Trust or the Smith Dynasty LLC. In fact, the concentrated position was held here. When the concentrated position sold at a larger transaction, assets went into the Smith Dynasty. They were invested. Income tax, this was all grantor, disregarded grantor trust. The income tax owed by Mr. Smith was there because he's considered to be the owner. He pays the tax on the stock that was sold here. Well, what we did was just transfer cash out to Mr. Smith in satisfaction of the self-canceling installment note, right? So he got a big distribution, I think, of around $5 million or more than $5 million, and he used most of that to pay the income tax on the sale of the concentrated position, and therefore reduced the self-canceling installment note. The balance of the ownership that Mr. Smith had, he had 10% ownership. He transferred to a GRAT, which is not showing here, another GRAT, which provided that he would get paid, something like 28% every year for 4 years, and then whatever remained after the end of the GRAT went to the same Dynasty Trust here. So this Smith Dynasty Trust was something that caused basically a passage of wealth to be held in a slat for the benefit of Mrs. Smith and the descendants, similar to what occurred under the GRATs that we described earlier. And when we fast forward to this Dynasty Trust, I'm showing it here. I'm also showing it on this side. It has 20 million of assets, right? Because it itself was owed a conventional note from J&J Dynasty LLC to the Dynasty Trust. And in satisfaction of that note, ownership was transferred out to the Dynasty Trust to help remove wealth from the estate. The SCRAT can be complicated. I recognize that this probably is not the right medium to go over it in detail. I suspect we'll do something like that in more detail. But the gist here is that the installment sale to a grantor trust works. This is a derivation of that. And when you use these vehicles in the right manner and you have the right protections in place with the right trustees and right trust protectors, you can have immense amounts of wealth pass outside of the estate for federal estate tax purposes, while preserving flexibility, preserving assets for the benefit of family members, and being able to be flexible and agile when needed for income tax and other planning purposes. One example of that is this Dynasty Trust here, or I guess we'll do it on the left side, the Smith Dynasty Trust, just as well as these two investment trusts, allow the trust protectors to appoint or give the power to appoint to one's estate to one of the beneficiaries for the purposes of generating a step up in income tax basis under each of these questions or each of these trusts. And that means that if you have a beneficiary who is not going to have an estate tax problem down the road, well, each of these trusts allow for assets to be subject to estate tax inclusion in a grantor, in a beneficiary's estate, by giving that person a general power of appointment to appoint assets to the creditors of that person's estate, so that to get a step up in basis. And we haven't gotten there yet with the fact that the estate tax exclusion amount is still pretty high, and the senior member of the generation here, of the family rather, Mr. Smith, just died this year. But it's a tool that we have in our toolbox that we can use for tax planning purposes. And one of the reasons why I put this together was because it shows how, a holistic approach to wealth transfer can also mean income tax savings and non-tax objectives, such as, for example, structuring the child's house in an investment LLC and having the co-trusteeship that you would have on a trust of this type to protect against one trustee going rogue or spending assets in a manner that do not necessarily facilitate or carry out the intent of Mr. Smith and Mrs. Smith when setting this up. I hope that this was helpful. I recognize that there's some complexity here. I appreciate you joining us today, and stay tuned. We have another webinar coming up next week. I believe it's Calculator of the Month, where Alan and I will go over one of the estate view calculators to show you how they work. And really, one of the benefits of estate view is these calculations that we did a decade ago or more, they were quite a bit more difficult back then. But estate view now does these calculations. It can calculate the GRAT payments. It can calculate the amount of the expected remainder interest. Likewise with a self-canceling installment note, or just your garden variety installment sale that we reviewed here, right? Those types of calculations can be done over estate view. I'm not sure what we're going to go over for the calculator next week, but I'm sure we'll give a brief tour at least of how these various calculators work. And you'll see how estate view coupled with some creative thinking and structuring can really result in fantastic consequences for clients, both on the tax planning side and otherwise. Well, thank you again for joining us. I hope everyone has a wonderful holiday weekend and an excellent day.